I went up to him Wednesday morning and I said, dude, I got to tell you something, man. You are a badass. I freaking like you. After your case went so shitty on yesterday, your balls to pull the offer, I go, look, that's the worst decision I've ever seen. It's the worst decision I've ever seen, but mad respect that you did it, because unlike other people, you didn't suggest to me that you're going up. You suggested to me that you have a lot of job security, because that decision will cost most people their career.
All right, everybody, welcome to another great episode of Cases Gone Wild. I'm John Marco with Marco Law, and we're happy to have you here listening today. And we have an awesome, amazing guest, one of the best trial lawyers in the country. He's hot. He's hot. Not only does he come from a hot place, Vegas, but he's hot off some huge verdicts, big verdicts, massive verdicts. He just got a massive bad faith verdict over $140 million that he's going to talk about today. We have Sean Claggett, a good friend of mine, a great lawyer, who's also speaking at the Michigan Trial Lawyers Summit this summer on June 20th and 21st in Detroit, Michigan. So you're going to love the show, and Sean's a great guy. Remember, please share this. You can watch us on YouTube. We have video for you. We dressed up. Sean put on a t-shirt today. I put on a hoodie. So we spent a lot of time getting ready for this show for you. Sean had just flown in. He informed me from his trial, and he wants to be here to talk about some of his cases gone wild with you. So give us a like and share with your friends and family. Sean, thanks for being on the show, buddy. I know you just got off of a trial. I know how it is, and it's really great to see you, my man.
Hey, thanks for having me. I'm excited to be here. It's fortuitous that this was scheduled a long time ago, and I happened to do a trial that finished a couple of days ago. So it's good stuff.
It's perfect. And it's like, great. We don't have to talk about, like, we get to brag about how awesome you did instead of, talking about like, oh man, like, well, this is what we would do differently next time or whatever. But I know I don't have to worry about that with you, my man.
Yeah, no, this one turned out well, but very predictable. Very predictable. And it's kind of, I guess we'll talk about it a little bit, but the defense had no idea what was happening during the trial, why it was happening, and they certainly didn't properly value the case. And it's kind of a lesson learned in what it means to understand the value of a case and the dangers both ways for plaintiff lawyers and defense lawyers, what can happen. Because if you don't understand the true value, you put yourself in a position to not understand when a good deal is offered. And that was what exactly happened in the case that we just tried. So it was a pretty wild negotiations that occurred that I think is worth discussing with your listeners.
I'd love to hear about it. My viewers are excited. Tell us a little bit about yourself for those that don't know you. You're in Vegas, right?
Yeah, I'm in Vegas. Our practice basically, we're in 33 different states trying cases and involved in cases all over the country. But love Vegas. As far as my background, a lot of people don't realize this. It's not like I've been a hardcore trial lawyer my whole career. I didn't really start doing personal injury until, about 2010.
Wow.
And so the first, 7 years of my career, I was just a solo guy kind of doing whatever would pay, and didn't know that I wanted to do personal injury. I'd done a personal injury trial back in like 2005, and then my client got rear-ended, and I somehow lost the trial. And being a criminal defense guy, I couldn't even understand how I could possibly lose the case. But I did. And I was like, I don't like this personal injury, stupid. And so I didn't do any, I didn't get back into personal injury for a long time. And I didn't try another personal injury case for, it was like 8 or 9 years. It was a while, so my journey to being a trial lawyer was one that probably is not, I don't know if it's common or not, but certainly I never viewed myself as going to be, I didn't have some great desire or understood why I would want to do personal injury. But as I got into it, it really, obviously this concept of representing people just resonated with me. And it was so much more enjoyable to do than some of the other law I was doing. And obviously the idea of being in trial was always fun. I was a criminal defense guy starting out. And so I love being in court. And so, yeah, that's kind of what happened. And then I started to learn. I mean, the first time I went to a conference where I realized there was ways to be really good at this was Dorothy Clay Sims. And I was just a face in the crowd, man. There was like 400 or 500 people in a big auditorium type thing in LA. And I went there and I was just so blown away. And she's like, you got to read 2 books. And I'm like, whatever you tell me to do, lady, I'm doing it, because you know what's happening. And so I bought her book, so I knew what to do with medical experts, because, I didn't know what I was doing there for sure. And then I read Rules of the Road by Rick Friedman, and the Reptile that was David Ball and Don Keenan. And so, and I ended up going to a conference after that in Costa Rica with Don Keenan and David Ball put on, and learned the reptile stuff, and did that for about 5 years, and moved on from that when that got a little dogmatic, and the everything has to be one way didn't make any sense to me.
Right.
And so we moved on from that. And then, I was fortunate to kind of be in the right place at the right time when COVID hit. I'd done a case analysis with Dan Ambrose, and when COVID hit, I had always kind of thought I thought it'd be fun to teach off of my trials that were on CVN and explain to people what was happening real time. Like, why did you do that? Why did, like in this particular case that I just did, if you watch one of my cross-examinations of a witness, Roger Dodd who's a good friend, would tell me that was the worst cross I've ever seen, because it doesn't follow anything that anybody would ever teach. But in this particular setting, I've learned that when there's certain very evasive people, and they're going to talk around every question you ask, let them do it sometimes, because it's so evasive, and you can just start asking really basic questions. And that's what I was doing. And he wouldn't even answer the most basic questions. So, kind of those cool things that happen. And so, and so doing the teaching from CVN, you could show that happening and people would watch. Like, why did you change up your total method right with this witness? You can then explain why that happened. Well, then COVID happens, and then the rest is kind of history, because I told Ambrose, I said, listen, this is what we should do. And so that became what is now TLU, because we started teaching via CVN, and the folks over at CVN are awesome. They allowed us to use the footage to teach from, and then, Dan was like, do you know any of these other lawyers? And then, sure. And then CVN started pairing up lawyers that would be willing to teach with Dan. And, so I did that for a long time. And, that was kind of a fun thing. And I learned during COVID, that 9 months, I became exponentially a better trial lawyer, because I sat there every day and watched these people teach for 9 months. And I came out of COVID, I'm like, dude, every one of these defense lawyers is going to be paying consequences for this, because it's unbelievable. I was 10 times the lawyer I was in March of 20. By March of 21, I was 10 times the lawyer. I was so much better. I learned so much.
You went to all these things. You learned from a lot of others, which I love to do as well. But you are one of the top trial lawyers in the world. And so what is one of your secrets to success? What would you attribute it to? I mean, obviously you learn from others, but is there another secret in your kind of success story that you believe you can attribute to how you rose to the top?
Well, I think that the reality is, I've always believed in focus groups. That was something early on that, back in 2010, I started to adopt, and I've done probably 800 live focus groups over my career. And so that certainly, when I get in front of a jury, it just creates this level of comfort that you can be your total authentic self, because you're so comfortable being in front of strangers. And then what happened along that journey of doing the focus groups is, I started to see patterns. Like, I'm like, why with this case, when I presented it 15 times, do I see there's patterns in responses to evidence? And I believe that to be a truth, right? And so I created my older brother, Seaton, who is the CEO of Focus Graphics, is super smart technology.
He's a great guy. I used him, by the way, on a case here where an excavator ended up hitting a guy who was on cancer medication. He had to stop his cancer medication, and he died. And Seaton helped. Great guy, because he did this. It was a very complicated. It was an industrial accident, but it was difficult to explain in pure words how it occurred. because I'd explain it and people would be like, well, wait a minute. And they'd have a million questions, which means I wasn't explaining it well enough. Seton did a bang up job. We got the case resolved after Seton helped me do some focus graphics. So just a plug
Yeah.
there, but
Yeah.
sorry
No,
to interrupt you.
no. So, Seton's awesome. I mean, and it's great because his background, he's an engineer, he got a master's degree in hydrology, hydroelectric engineering, I think is what it was, or something like that. Super smart guy. So he helped me create some software to track my focus groups. So we had this in-house software that I was using, and I was convinced that this ability to predict the outcome of cases was actually doable, because what everybody was taught, I don't care who you were, everybody was always taught that focus groups are great for issue spotting. They won't help you with understanding damages. And I'm like, that's stupid. I reject that. I just flat out reject that. My hypothesis is it can be predicted. And then I end up meeting John Campbell, who was writing some like crazy ass, awesome, peer-reviewed material that I was reading on the impact of jury selection and deliberations and all this cool stuff that was it's really neat that the work he was doing academically. I was an adjunct professor at UNLV's Boyd School of Law, and so I was looking at wanting to publish something, and I was kind of tracking him because he was doing exactly what it was that I thought was right. And so I reached out to John, and he was doing big data, and I had toyed around with big data. The problem was the data that I was getting was inaccurate, and we were pulling up the back end of the data and seeing that they were inputting information incorrectly, creating errors in the data. And so that just wasn't something that I didn't like the company I was working with. But then I started using Campbell, and we both had a hypothesis that we could in fact predict the outcomes. And then why is that so important? Well, because it greatly influences the cases we try versus the cases we settle. And everybody's like, dude, every case you try, you bang out for 8 or 9 figures. And it's true. That is a fact. Every single case I've tried over the past probably 7 years has either been in the 8 or 9 figure range. Every single one. And people are like, how do you keep doing that? Well, it's because I already know. I'm picking the cases that I already know are going to be bangers. And in cases that need to settle, we settle.
Right on.
And so the secret to my success is that it's really case selection, and the data is what's driving my decision making. And the hardest thing with data is to say I'm just going to trust it. In this last trial that we just did, I was absolutely convinced that the right way to tell the jury the value was per diem. I was going to do a per diem. There was 9 elements of the brain that were physically impaired, and I was going to want the jury to do a calculation on all 9 by the 55 years that this guy had been damaged and will live, and that was what I wanted to do, and I was just convinced of it. Well, that's an empirical question, whether you should ask for, tell the jury that way, or should you tell the jury just $1 million a year to $2 million a year? What's the better way to do it? There's a right and wrong answer. And so Alicia Campbell, this is the first time Alicia and I have tried a case together, which was super, super rad. And so we were testing this, and it turns out that if I would have given the tell the way I wanted to, I was hurting the win rate by like 12%.
Wow.
And I was hurting the damage model by about 20 million. I would have my instincts were wrong. They were just wrong.
So Sean, take us through this case, because you just got hot off. I mean, everybody's talking about it. What was the verdict?
145,260,000.
And that's a huge result. And I had heard that through talking to other attorneys, including one that was consulted about the case, that multiple other attorneys had actually turned this case down to try prior to you. Is that true?
Yeah, a lot of attorneys turn this case down. A lot of them. I mean, the reality is that I think a lot of the attorneys looked at it. The case hadn't been worked up at all, and so just kind of that scares you off as a trial lawyer. But I saw the case when it was brought to me. I really, really wanted to try this case. I said, I just get an extension, get a 60 days of discovery, man. Let our team come in and take some depots. Just let me get a base level of depots in this case. And so the attorney was able to get the continuance. We went in, and Jim Murphy from my office went to town. I mean, Jim is This dude's he did 20 years on the defense, buddy of mine from law school, and he joined my firm a few years ago. He is just unbelievable at working cases up. And he went in and spent 2 months on the road doing depots, did 16 depots, did some written discovery, got us to a point where we had at least enough where I could tell the story. But so the basic
tell
story,
us about the case.
yeah. So the case is this: a 20-year-old guy, my client Fermin, was a painter for a company called Castro Brothers.
And where is this, Sean? Is this in Vegas or?
No, this case is based. The company's based out of Denver, Aurora area.
Okay.
And so Castro Brothers, small little company. It's David Castro and his brother, and then it was my client Fermin and his brother. I mean, this is a real small outfit.
Yeah.
And they get work from general contractors. And so one of the general contractors that they get work from is this company called ECC, huge company that has hundreds of subcontractors. And so they get a job to go paint some apartments in Utah. So, all right, yeah, let's go. So they hop in the truck and they go to Utah and they're painting. And Fermin is told by David, hey, go, there's some branches up against the apartment building. You got to remove the branches so we can paint. So Fermin's up there doing that, and he falls down and hits his head and suffers a severe catastrophic brain injury. And he's non-responsive. His Glasgow coma score is a 3.
Oh my God.
Yeah. So
that's really bad.
It's as bad as
like
it is.
death. I mean, yeah.
The scale only goes down to 3. For those of you that don't know that, it's a 3 to 15 scale, and 3 basically usually means not survivable.
Right.
And so Fermin goes to the hospital, and they life flight him from a little local hospital to University of Utah, which is a great hospital there in Salt Lake. And University of Utah goes to work on him, and they basically are like, well, we think we should pull him off life support. And Fermin's family, which is very religious family, said, no, God will answer our prayers. Our son will make it. And they sat by his bedside and they prayed. And the University of Utah did their thing. And sure enough, Fermin comes out of the coma. And while he's in the coma, though, the worker comp carrier, which is Berkshire Hathaway Guard, the paper was written on Norgard paper, but that's just Berkshire Hathaway Guard, one of their names that they use. So Berkshire Hathaway basically, while the guy's in the coma, while Fermin's in a coma, they have 20 days to accept or deny the claim. And they decide that they're going to deny the claim, and their basis for that is that we're going to say that Fermin does not work for Castro Brothers. We're going to say that he's an employee of ECC. No evidence of that. I mean,
the general contractor. ECC is this general contractor.
Right. And the law in Colorado is if the subcontractor has worker comp insurance, you cannot do this. You absolutely are not allowed to push it up to the general contractor. The liability is the subcontractor. So it was just wrong. I mean, it was just a malicious denial. And that denial, University of Utah is like, hey, this guy's waking up. He's starting to do a lot better. We need to send him to Craig. Now, that's the whole irony of this is that Craig in Denver is the number one.
The number one.
Number one in the whole United States.
I have a guy right now in Muskegon, Michigan. We have a case. He's working inside of a tube, falls, similar thing, falls, massive brain damage. We got him to Craig right away because that is number one. From Michigan to Craig. And Sean, isn't it like the most important rehab time for this type of injury is like directly in the first year after? Like
100%. Yeah. I mean, it is, there's your brain after an injury, whether it's a stroke or a traumatic brain injury, goes through this process called neuroplasticity. And that's basically when the brain is reconnecting itself, and it's unbelievably resilient. And so they know in the first 12 to 18 months that neuroplasticity is just going, and it's day one. I mean, every day it's a little less. So as you're going, it's not like equal. It's not equal on month 18 as it is on day one, right? So you got to be in there
because your brain's rerouting all the wires, right?
That's right.
Having to redo all the pathways.
That's right. So if you've got dead parts of your brain, it's going to find a way around and it's going to reconnect. And so that's right. And so what happened is they don't send him to Craig because it's denied. There's no coverage, and Craig won't take you if there's no coverage. And so they removed my guy's feeding tube.
Wow.
On November 22nd, 2021. On November 23rd, he's on a Delta commercial flight that the family had to pay for, sending him from Salt Lake to Denver.
With no medical help.
No medical care at all.
That's horrible.
Right. Well, yeah, that's right. That's why this verdict is so damn big, because ultimately he doesn't get any proper care. He got a little bit of outpatient at Craig 6 months down the road, which was stopped because the worker comp providers, it was a total mess. He didn't have the right equipment, he didn't have the right support, and so
That's
they
despicable.
Craig was like, "Come back when you get this figured out. We can't keep helping you. This is not working." And then he never got back to Craig, and then. 2 year, 26 months later, after we filed the bad faith lawsuit, they finally put him into an inpatient, but it's just way too little too late.
Yeah, it's too late.
Yeah, and so they were, and it's interesting during trial that the defense totally screwed up. This was a massive error, and I told them real time that you guys have made a mistake that you will pay for. This is going to be a massive change in the value of this case, and they suggested to the jury that they will be paying $15 to $20 million to care for Fermin in the workers' comp setting. And what we knew is that they had actually just had a doctor evaluate Fermin, their chosen doctor, Dr. Wonder. Unbelievable.
Is his name really Wonder?
Yes, I swear to God, dude,
Wonder?
you can't make it up. And he's one of those doctors that we all know about that say that nobody's ever heard doesn't need treatment. And his opinion was that Fermin didn't need any future treatment. Just give him 24/7 daycare, but no speech therapy, no occupational therapy, no physical therapy. It's all
That's
done.
horrible. That's
So
horrible.
They are lining up.
So they lied.
100% lied, and they've got it set up right now to start denying all the care because they now have a doctor that's saying he doesn't need any medical care.
So where did you try this case? Was it in Denver? Or?
Yep, Denver. Yep, downtown Denver, state court.
And so take us through. So did you use big data to prepare for the case, and did it help influence your decisions? Because you alluded to that your damage ask was changed.
Yeah, so for sure. So we originally ran data. So we got involved in this case only like maybe 3 months ago or so. Maybe 3 or 4 months ago. It's just recent. And so we ran our first big data. And when we ran the first data, there was two other defendants that Colorado has a really bizarre law that basically allows a capped defendant in a med mal setting, which is what we had. In a med mal setting, if they tender the cap amount, they get automatic dismissal. They're out. You don't have any say. And so
you had a med mal component to the case too, or
right? Yeah.
Okay.
So the Berkshire Hathaway had selected a nurse case manager to help Fermin, and this nurse case manager was a disaster. I mean, she was awful. And so the attorney who had the case had originally sued under med mal. I would have preferred that they just had what I really wanted, and nothing I could do about it. It was too late, but I would have preferred that they have been sued under a theory of agency and said their conduct is attributable to the bad faith of Norgard and Berkshire. But that's not the way it was. So they ultimately get out. But when we originally ran the data, we didn't have punitive damages, and these other defendants were in. Well, having that defendant in was a disaster for us.
Having what defendant in?
The nurse case manager, the med mal case.
Why did they got to a? Oh, you mean she was dismissed before trial or no?
Yeah, she was dismissed right before trial. But the data we had run, the focus group was confused. It was confusing the issue because you have this bad faith case and you have this med mal case, and it's just
two different
confusing.
things, apples and oranges. Yeah.
Yeah, and so the win rate just wasn't where we wanted it. But they solved our problem for us because they got dismissal. And then there was a motion by Norgard to preclude us from mentioning anything about this nurse case manager. And the judge granted that. And so nobody could talk about what she did or didn't do. So it just became this like really weird thing in trial that you're just like, okay, well, it was really crappy. Look at all these denials. He wasn't getting timely care. Like the wheelchair, his doctor ordered it in August and he had to ask for it in December. I'm like, dude, seriously, it's crazy. And so, but there was no real explanation. We couldn't explain what was actually going on because the defense procedurally were really good in this case. They beat the living tar out of me the whole trial. I mean, I lost everything procedurally in this case. I literally, it was a bloodbath for us. We didn't do a very good job of complying with the court's orders, the local rules that I was unaware of. And so
Yeah, right.
I was made well aware of all the local rules throughout the trial, after objection after objection after objection being sustained by the defense. So it was, this was a really, really hard trial emotionally to keep your cool, because you're just getting beaten every way. But the defense thought that was making them win the case. But what they didn't understand is the story that was being told was catastrophically bad for them, and they couldn't separate the two things. Like, okay, fine, you're beating me procedurally, which is great for me on appeal. They don't have crap on appeal because they won everything. They won all their legal issues.
Yeah.
They won. Good job. But the judge substantively, when it came down to our causes of actions we did have, was absolutely like, yeah, I'm not granting directed verdict. No way. Like, there's a lot of evidence that would suggest that a jury is going to find bad faith, extreme and outrageous conduct, and come back with punitives. I think that's likely in this case, the judge said.
Wow.
So procedurally, they kicked my ass, but substantively, the facts of the case were still coming in. There was a lot of things I wasn't able to tell the jury that would have probably amped up the verdict, I think, a lot more.
Did you have local counsel who was supposed to be helping you with these local rules and stuff?
Yeah, our local counsel is a great guy. It's just one of those things that, according to, his explanation, is that this judge was taking a very literal view that a lot of the judges don't do. But I didn't feel that, honestly, I thought the judge was really good. I was frustrated more so with us than the judge. There's a great judge in Las Vegas that is very similar to this judge, and if you can't follow her rules, she will make your life hell. And
it can be very frustrating. My last trial, we had all of our experts stricken, and I got in late. I got in like 2 months before trial, and I was told, like, don't worry, we're going to be able to get all these people in, because I said I need my experts and stuff. All my experts got stricken, and we had no depositions. Okay, we had no depositions. Sean, when I say no depositions, not one. Okay, not one deposition, and it was in federal court. So we won. I got $13 million. And it's easy looking back and saying that's great, because now there's like no appealable issues. But when you're losing procedurally, it feels like death by 1,000 cuts, right?
It does not feel good, dude, at all. I mean, doing what we do, John, and hopping into trials late to try them, you kind of, our job is to fix the problems that exist and to pivot. That was our big theme in this case. Let's pivot. We got to pivot again. We got to pivot again. You got to be flexible. You got to pivot. And so when all these major roadblocks kept coming up, it's like, it's okay. And it was interesting because during trial, I want to say it was like middle of the first week, I called my wife, and I had to take a walk because I was just so angry at the self-inflicted wounds. Because trial, one of my rules that I tell my own firm is, I'm like, listen, we just limit the self-inflicted wounds. If we do that, we're going to be okay. This was a case of the most self-inflicted wounds I've ever tried. And I went out and I just had to get away from the whole team. I just needed a break to just clear my head. And I called my wife, and I was talking to her about my frustration, and she gave me the best advice I've ever had during a trial. And she was just like, you're telling his story, and his story matters. Focus on that. And it's just like, you're right. All this other bullshit really doesn't matter.
Right.
My job is to tell my client's story and stay focused.
And Sean, you said that you tried not the case that they thought you were going to try, which I love to hear. It's always a sign of I think a great lawyer. Jeffrey Feiger, who was my mentor and who I worked for, one of the biggest things the defense would say is he would get involved in a case and the case would change. And the defense would say, what case is this? This isn't the case we've been defending for the last 3 years. So can you tell me about that? Like what happened there?
Well, so I 100% agree on that. The one thing I don't take depositions. I have other people always take the depositions, and I see what they get. And then when I go and cross the defense witnesses, because we call them all in our case, they're all prepared. They always prepare based upon what they did in their depot.
Right.
I won't ask a single question that's in the depot. I will totally go on a different angle because there's a different story that I want to tell. And in this particular case, it was really simple. What happened is that denial at the beginning created this whole environment down the road that as the doctor who was ultimately the appointed doctor to in the worker comp system to oversee everything said, I had to recreate the will because somebody like this never should be with me. He should be inpatient. He should be at Craig. Like I don't see these patients. This is crazy. And so what we did is we basically took the story and we very much simplified it. And we said, this is what it's about. But by the way, because what their theory was is look at all these benefits we did pay for. And it's like, basically we were like, okay, take all that away. Where's the brain treatment? You know? And they weren't ready for that. I'm a little surprised they weren't ready for it. I thought they'd be ready for that. They didn't know how to deal with that. And so it was kind of surprising. And they brought in a big wig. They had a very good firm out of Kansas City, and some, I thought, really talented trial lawyers. And then they brought in this firm out of New York with these Harvard educated yahoos that were like, that they were using freaking words I didn't understand. And just, they were weirdos, man. Honestly, like, I was like, bro, I go, bro, I don't understand. You know, I don't understand that shit. I went to a community college, bro.
Yeah.
I didn't go to Harvard, man. I grew up I grew up in Idaho next to a dairy farm, and I went to
Yeah.
junior college out of high school. I'm not as smart as you clearly, and I don't know those big words, but I know one thing:
Yeah.
the jury hates your guts. So
Yeah.
keep going. I mean, I had some funny text messages I was sending the defense team, like thanking them for this highbrow attorney out of New York, the Harvard educated guy. I was like, man, I think I should pay half of his. I should be paying half of his hourly rate for you guys. He's so good for me. Keep having him stand up, please.
Yes.
He was really awful, very very unskilled, and made a lot of catastrophic errors, but was so narcissistic in his view of himself and everything that he found a way to tell the jury that if the jury believed my theory of the case, that they were like ostriches with their head in the sand. That's what he said in his closing.
Wow.
I mean, I was just like, there was a lot of discipline on my part because he said so many offensive things. He attacked me personally during closing. And my younger self would have definitely gone up in rebuttal and been like, fuck you. And I would have hit every point. But I'm probably most proud of my rebuttal because it was very disciplined. I hit on the one issue that I knew mattered from our data, which was make sure we get causation, because causation was tricky in this case.
Yeah. And what do you mean, like causation? Like, had he got the treatment that he should have gotten, none of this would have happened, or he would have had a better result? Is that what you mean? Or,
That's right. Yeah. So you're taking a guy that has this severe brain injury, and it's bad. I mean, this is a bad injury. And our neurologist, who was phenomenal, her name's Allison Gray, one of the best experts I've ever dealt with. I mean, she's super good. Dr. Gray testified that, had the treatment happened, he would have been better in all these areas, 9 different areas of deficits. And the defense whole theory of the case is you can't guarantee us how good he would be. And she's like, you're right, I can't. I can't because you stole the time. But what I can tell you is the medical literature supports he would be better. And in my personal treatment of patients who have been just as severely injured as him, the ones who've gone to Craig are independent, working, going to school. He shouldn't be this way. That's what I can tell you. He shouldn't be how he is right now. That's what I can tell you. And so I was just super disciplined. And I think that just came from knowing what the data was telling me, that getting into the gutter and addressing the lies. The jury, I saw that the jury wasn't buying what he was selling. It was total gaslighting. I mean, it was like you're sitting there. If you listen to the closing arguments and just those alone, you would be like, I'm not sure who's going to win this case. Like who's telling the truth? But the problem for him is that everything he was saying was just not
a lie.
Consistent. It wasn't consistent with what actually happened during the trial.
And that can make damages go up, right?
And it did. I think it did. I mean, I think the way they defended the case, our data suggested that the likely verdict in this case would be 114, and it came in at 145. So, I mean,
that's a Sean Claggett factor, baby.
Well, this is the first time I tried a case where I beat the data. So I'm pretty excited about that. My partner Jordan Logan had beaten the data in a trial that we did a couple years ago, and he's always use that to rub it in my face that I don't know how to beat the data. I'm not good enough to beat the data. But this one we did.
So tell me, and I know you're going to talk about, you're coming to the Trial Lawyers Summit here in Detroit. Have you been to Detroit, by the way, before?
No, I haven't. But my nephew lives in a suburb of Detroit, and he is a pilot. And I'm super excited to come up there and spend some time with his family. We were just in the Philippines for his wedding, so we're super excited to spend some time with him this summer.
Where does he live?
Uh, I don't know
Suburb?
exactly. Yeah, he's in a suburb of Detroit. That's what I know. I don't know
All right, well, you're going to find out. You're going to find out. And we're excited to have you. We're going to have a blast. And we're excited to hear you talk about big data. And tell us, for this case, like, do you always use the same big data company? Like, how do you do it? Because there's so many options out there nowadays. There's just so much out there. What do you recommend? What do you think's the best?
Well, I mean, look, I think that that my personal opinion, and obviously it's probably quite biased. I wrote the book with John and Alicia Campbell. Uh, their data is just dead on. I mean, it's so accurate, it's insane. I mean, at this point, John, Alicia, and I have worked on cases that have resulted over $7 billion now over the last 5 years, and we've predicted the outcomes. You know what I mean? So uh, that level of accuracy, and the data scientists that are the backbone of this, like we're having the Jury Ball Madrid conference next in like 10 days
Yeah.
out in Spain. And, when you see that the data scientists that we're using, I mean, they're the top people at like Cornell, I mean, these people, the data scientists that we're using are brilliant. And
So how does this work? How did this work for this case? Do you do a presentation, or what is it? What happens?
Yeah, so we provided the information initially, and then as things changed, right? We got rid of the nurse and her company, so that was out, and we had gotten the judge to agree that punitive damages were appropriate. So now we got to retest, totally different case. So we retested that, and then we got information. We're like, okay, this is what it looks like. And then what we wanted to do, and it was really fascinating. And this was more of just a research project for John, Alicia, and I. Were like, hey, let's have big data look at the opening statements. And what's really cool is there is a new thing that we're looking at doing is the likability of the lawyers. How do people feel? That feeling, just the gut feeling. How do you feel about a lawyer? And they get scored. And there's, it's on a 5-point scale, and each point is a standard deviation up or down, and that's significant, right? We're saying that can result in a statistically significant change in outcome of the case. And we started out, and I was over a whole point higher than the defense lawyer after openings. So our presentation when tested was that real time we were ahead. Then after day one of witnesses, we were way ahead. I mean, it was a lock. And so
they're doing this in the trial.
Yeah, we were running data during the trial.
And how does that work? How do you guys actually do that?
Well, we were able to use the weekend because the trial went for more than a week. We were having folks basically get the real-time information that was going on in trial and presenting it to them. And then we were able to run a study and have them look at it. And it was, this isn't for, at the end of the day, it's not a marketability product yet because of how much bandwidth it took of the company to do. But we are working on our the second version of Jury Ball book, which is going to be the evolution of data. And so this was kind of why Alicia and I chose to try this case together, is that we wanted to test the.
Well, it worked. It's
test
amazing.
This. Yeah. So I mean, what we basically did is on Sunday we got the report back after the first week of trial, and that led to a negotiation that occurred. I mean, I think what's really interesting is to understand how the negotiations in this case went.
Yeah.
Because, it's not like we were being offered money on this case, really. I mean, we got involved. I went to a mandatory settlement conference 5 weeks before trial, and the top offer was $750,000.
What?
Yeah. And so, at that time, this is when the other defendants were still involved. I bracketed the high and the low with what the compensatory number looked like at the time. And so our best day was around 56.6 and our worst day was 15. Okay. And so I said, we'll bracket those two numbers for resolution. And so kind of suggesting we take like mid 30 number to settle it. And of course their top offer is 750. So we left, we start trial. I do my jury selection before opening. They offer me 4 million. So that's on a Monday. And then on a Tuesday morning, we're about to start witnesses. I asked the defense attorney, I go, hey, just out of curiosity, is this 4 million global for the worker comp case and the bad faith case, or is it just the bad faith case? And they confirmed it was just the bad faith case. I'm like, okay, thank you. And then I just ignored it. I wasn't going to respond because my data, we were so far ahead at this point. I was like, no, just let that go. And then interesting though, that night, Tuesday night, when I didn't respond, they let me know that they've pulled the $4 million offer and we're back to zero. And I was like, dude, this is badass, dude. This guy's balling over there. So I went up to him. I went up to the
Harvard guy,
the executive from Berkshire Hathaway, and I went up to him Wednesday morning and I said, dude, I got to tell you something, man. You are a badass. I freaking like you. I like you a lot. I go, after your case went so shitty on yesterday, your balls to pull the offer. I go, look, that's the worst decision I've ever seen. It's the worst decision I've ever seen, but mad respect that you did it because unlike other people, you didn't suggest to me that you're going up. You suggested to me that you have a lot of job security because that decision will cost most people their career. But you,
wow.
my friend, made it, and I respect you, and I do respect it. I'm not being.
And what did he say to you? What did he say to you?
He's like, basically, he's like, look, man, I'm here to negotiate. I've got more. You got to counter me. And I said, look, I'm not going to counter you until I get my data back. I'm running real-time data. I will make you an offer this weekend that will be a significant discount to what the jury's going to do. Okay. I'm going to, you have my word. I will make you that opportunity. I'll give you that opportunity. And so I do. I then send him a demand, very detailed. This will be published. I'm going to publish all of this. I make a demand and I tell him, look, you can pay us $75 million within 30 days of today. And money must go into a QSF, or you can do a high low of 10 on the bottom, 85 on the top, payable within 30 days of verdict. Money goes into QSF. But I go, as soon as the last witness takes the stand, offers off the table. And so they didn't respond. Last witness took the stand. Real time, I had the last witness on the stand. I'm like, my offer is withdrawn. And then I did my closing, and after my closing, he sent back. He says, "Hey, I've got $3 million on the table. It'll stay on the table until the verdict."
Didn't they already offer 4 million previously?
Right. So they thought the trial went so well they were going backwards.
They were that delusional.
Yeah, which is strange because some juries, you watch their body language, they're just stoic. You can't tell what they're thinking.
Yeah.
And it's like, tough.
I know. I've been there. That's always tough.
This was not that jury. This jury was clenching fists, jaws tightened, legs shaking, anger, while the company is trying to defend their position throughout trial. I mean, they are pissed. And I'm like, this thing is not going well for the defense.
The guys from Harvard couldn't decipher that?
Nope.
God.
They thought they were smitten with their defense. They thought they did great. And they just...
Did they say anything to you afterwards?
When the verdict came out? I wasn't there for the verdict. I didn't. The jury started deliberating on Tuesday evening, like afternoon, and then went all day Wednesday, and I had other commitments, so I took off Wednesday morning, and I was here at my house Wednesday night with my late afternoon with my wife and my daughter when the verdict came in, and I will tell you that when the verdict came in, I was being texted real time. I mean, I could have hopped on CBN, I suppose, to watch it, but I just was so. I was just not. I'm not one to think that taking verdicts is good for your health.
No, so. God, it's That's the worst part for me of the entire case cycle is waiting on a verdict. And
Yeah.
when I was with Jeffrey Feiger, he took one single verdict in the entire time that I've tried cases with him, only one. And I think he knew what was going to happen, but most of the other times he was out of there before the jury instructions were even finished being read.
I don't take. I rarely take your verdict. I'll take a verdict if there's like a second phase of punitives or some reason why I got to be there to take it.
Yeah. Well, that's a great result, dude. That's a great result, Sean.
Yeah, the defense is they were shocked. They were shocked by the verdict. And the thing about the reality about this is that the verdict actually wasn't shocking at all to me. I mean, it was predictable. We knew this was going to be a 9-figure verdict. I told the defense in my letter this is going to be a 9-figure verdict. It's going to exceed 114 million. And they look. They actually kind of got lucky, and the response from this guy, the guy from Berkshire Hathaway, was, you didn't get the 500 million you asked for. I'm like, that's true, but I also didn't tell you that I thought that was what was going to happen.
Right.
I told you it was going to be in excess of 114. I didn't tell you that I thought it was going to be 500 million, but they got really lucky because it needs to be unanimous in Denver in these cases, and
wow.
And look, this is how much we knew we were going to win. You can stipulate to have the alternate deliberate. And we had the jury read so well. We're like, we want the alternate to deliberate because she is fantastic for us. And the defense not understanding, and they just thought better to have 7 than 6. They need unanimous verdict. They stipulated as well. So the 7th juror went back and deliberated, and guess who the 4-person was?
7th juror.
Yep.
Yeah. Well, that was.
They let our biggest. They let our biggest advocate in the back of the room.
It just shows how clueless they are.
Yeah. I mean,
they are.
That was the thing, is you may be from Harvard, but you ain't from the school of real trial law. You don't know what the hell you're doing. And he elicited. This is how bad it was. There was a conservator, right? And I had to call the conservator in the case so the jury understood why this guy was on the pleadings.
Yeah.
Right. And so I just called this conservator guy, and he's a true court-appointed conservator. It's not like he's some friend of the guy. And so there's only 2 conservators in Denver that speak Spanish. So it was going to be him or another person. So he ends up being the guy, and I explained, like, how do you, what did you do? Like, why did you bring this lawsuit? And it was kind of interesting because he's like, well, I don't do workers' comp and I don't do bad faith, so I went and had to get independent evaluation from other attorneys to see if this case had merit. And after consulting with them for a number of hours and going over the complaint that had been provided to me by the bad faith attorney that wanted to pursue the case, they agreed that it not only could be pursued, that it should be pursued because they thought that it had merit. And so that's why I brought this case. That was it. That was why I was calling the guy. I would think a better attorney would say, I don't have any questions for this guy.
Yeah.
But instead, they wanted to score a point. They wanted to score a point because the plaintiff lawyers have been paying for the bills of this conservator. I didn't know this. I didn't know this fact. I didn't know anything about who was paying for the conservator because there was a court order that the Norgard pay for the conservator.
Wow.
That's what I knew. I didn't know. And so he's trying to score a point on this, and the conservator's like, well, sir, you understand that your client, Norgard, is in violation of a court order currently. And if the plaintiff lawyer wasn't paying my bill, I would be unable to continue as a conservator. So the only reason why they're paying is because Norgard is willfully violating a court order. And I was just like, what? I'm like, yeah, baby. I didn't even know that, bad faith. Thank you for that. God. I didn't even know, because
this sounds like an awesome trial.
This was stuff like, I mean, when I tell you that I wasn't getting like a lot of help with like what was going on real time. I mean, I was piecing all this stuff together. I just wasn't getting a lot of information. People didn't feel necessary to tell me.
Yeah. Well, you did a hell of a job, dude. That's amazing. Do we have time to talk about one more case? I know you won a huge verdict involving child abuse. Do you have some time to
Yeah,
talk to us
for
about it?
sure. Yeah, man. That was a case out in New Mexico. Um, and it turns out it was the largest verdict in the history of New Mexico. It was involved a treatment foster care and a company, a terrible company. It's Acadia Healthcare. They are a really terrible company that have destroyed mental health care for the youth in this country in ways that I'm so proud of the work. I honestly, this is one that chokes me up every time I talk about it because our mental health care in this country is a disaster.
Sucks.
And it's a disaster because of one person named Joey Jacobs, who's since died. But this guy found a way to make mental health care profitable in a manner that a lot of money could be milked out of these insurance companies. And they would start, he figured out that all we have to do is give the diagnosis that will return the best amount of money from these insurance companies, irregardless of what the mental condition of the patient is. And then along the way, how else do you save money in mental health care? Get rid of all the qualified people that require higher pay and put a whole bunch of unqualified people in there that maybe have criminal records, abuse kids, and then cover shit up. And in litigation, Acadia destroys evidence all of the time. Every single case I've had with them in states all over the United States, they have destroyed evidence. I've gotten their answers struck multiple times. And so this particular case involved a whole bunch of little girls that were under the treatment foster care of this individual named Clarence Garcia, who's now in prison for raping a whole bunch of these kids. And so we did the trial, and it was an interesting trial from the standpoint that the defense utilized, they clearly had read Nuclear Verdicts by Robert Tyson. And that was a book that during COVID, David Ball and I had read and decided that we were going to publish on a response. And instead of publishing a response, we just went on and presented to, I think it was over 5,000 unique lawyers watched David Ball and I present on how to overcome what's being taught in that book. And so it was kind of funny when I saw them employ those tactics. I was laughing because I'm like, oh, you guys are in trouble. I'm going to smoke you on this. And they decided, Acadia wanted this, they basically got to choose venue in New Mexico, and they chose Rio Arriba County, New Mexico. That is the poorest county in the United States.
Wow.
It is, you have not seen poverty. I promise you, I don't care where you are. Do not care. You take your poorest part of Michigan, you ain't seen it like this. They don't even have drinkable water.
Oh my gosh.
I mean, it's so bad.
And this company did what? They placed people in foster care?
Yeah, so they owned this company called Desert Hills. Desert Hills was a residential treatment center. Desert Hills operated a treatment foster care program called just know that they just operated that. And so Desert Hills operated this treatment foster care, and Acadia employees were the CEO and CFO of Desert Hills. So Acadia directly controlled the treatment foster. And so a big part of the fight was fighting over the corporate structure so that the verdict would be the responsibility of Acadia and not this small little bankruptable company. And so that was a big part of the fight. And we've been able to establish that clearly through undercapitalization and other things that become, obviously a little bit more technical and not so sexy as far as personal injury, but, something that lawyers should certainly be concerned about if they have a big case is making sure that you have the right defendant that can pay it versus getting a verdict against a smaller entity that files bankruptcy and there's no remedy.
Right.
So we ended up doing, this case was originally supposed to be tried, and this is fascinating. We were supposed to try this case October of 20. And it was like, I was so happy because like everybody else in our world, we were making no money. We were sucking wind. We couldn't do trials. And we go to do the trial, and we're going to do social distancing, and it was going to be really awkward. And then the defendants in that case had destroyed, we had been asking for them, they'd been sanctioned just a gazillion times in the case for discovery abuses. And then they come forward on the eve of trial with new documents saying that, well, it turns out we actually destroyed these servers, but we were able to capture some documents from them. And the judge lost his mind, and issued United Nuclear Sanctions. And in New Mexico, that's a case name from the 80s, but it's for discovery abuses. And basically, the judge ends up striking their answer as to liability, and reset the trial. And so the case then gets reset, and we can't get back on docket until July of 23. So it was almost 3 years we had to wait to try the case. And so we finally get a chance to try it. And so they're basically, it's a damage case, and it is super hard, right? I mean, these little kids that are in treatment foster care are there because they've been abused.
Yeah.
They've
Broken
had,
families,
yeah,
difficult
yeah,
situations.
drugs, alcohol abuse, everything. And so the defense of the case really was these kids are screwed up. And the defense of the case the whole time was that they weren't actually raped. And they kept that defense right up until the time that Clarence Garcia pled guilty to raping them. And so that was a fascinating change, because now all their experts were like, oh, I guess our opinions aren't valid. Like, it was disgusting. It was,
That's disgusting.
they actually Acadia hired an expert to say that there needs to be more sympathy for the perpetrators of these horrific crimes than the kids.
Oh my God.
I mean, it was I was like, I wanted to kill that guy. I was like, dude, you are hurting kids right now. There's no doubt in my mind that you're
Right.
one of these people. Saying this is nuts to me. And so we ended up doing that trial, and the defense in that case essentially was not our fault. It was the state of New Mexico blew this, the state of New Mexico.
So did this company place, is this like a private foster care placement facility?
Yeah.
Like we have them here, like they're in charge. The state says, we're too busy or we don't want to do this. You do this and we'll pay you. And then,
They licensed Acadia to basically handle all of it. And so the state New Mexico does not have the resources. Honestly, it's just a very poor state. And so they relied on a private company to do it. And the private company, they had, this guy had been accused of raping girls all the way back to 2000, the year 2000.
Oh my gosh.
And every time there was an allegation of a child, they would determine, like, the child would go somewhere else, they couldn't speak to him, or the kid would recant because the Garcia still had access to the child, and all these things that, it's like, well,
and a lot of time nobody listens to these kids. They dismiss them. They say you're lying. It's horrible.
Yeah, it was you delayed in reporting, then you recanted. All of this stuff is normal behavior, by the way.
And there's no way to report a lot of the times. Like, who do you really report to,
Yeah. And so our little girl, in this case, was the way this all kind of came about is that around the same day, I think it was the same day, actually, our little girl had gone to school and had a bunch of, like, bleeding from her legs. And the reason why she was bleeding is because she was duct taping her legs closed at night.
Oh my God.
So she couldn't be abused. And then another one of the little girls had climbed a tree and wouldn't come down from the tree. So they called the police. And the reason why she wouldn't come down is because they would deny her food and drink unless she agreed to be raped.
Oh my God.
And so she's like, I don't want to do this anymore. And so this all kind of just exploded into this big investigation. And then what came out of it is all of these prior red flags where these kids have been raising this issue, that they just ignored over and over again. And so they went to trial, and they told the jury at the end that, look, if you believe we did anything wrong, which we dispute, $3 million is a lot of money. It can buy this little girl a college education. It can buy her a house, a car, braces. And so I got up in rebuttal, and I basically said, look, we're not talking about braces or school. We're talking about a child that the rest of her life will be a victim of rape, of somebody who was in control and in a trusted position. That's what this is about. So we had done big data back in October for that trial, and we had tested up to 125 million. And understand, this is 5 years ago that we were doing this, so we had not evolved as much. in the knowledge that we have with data, but we had done up to 125. We were a 99% win rate at that number. And so we thought, okay, we'll ask for 125. But when the case got continued, we were like, hey, you know what? We we are at 99% win rate. We're not asking for enough. And so then we tested it up to 500 million and we still weren't getting any pushback. And then we tested up to 1.1 billion and we finally saw, okay, we're getting to the point where people are starting to think that that's too much.
Wow.
And so we knew, so we went from an ask of, or a tell of 125 to a tell of 1.1 billion based on data telling us that that was an acceptable value of the case. And so the result was that we got $485 million verdict. Now the
Single plaintiff. Single plaintiff?
Single plaintiff.
Wow, that's an amazing result.
Yeah, and so the fascinating thing is, think about the mistake I almost made of only asking telling the jury 125. It would have been a catastrophic error. And so we corrected that. And then what's really fascinating, I think, for people to know, and this is, I lecture on this a lot, is the high level negotiations for collecting money. One thing that I don't ever want to be known for is just getting verdicts. I want to be known for the guy who gets the verdicts and gets paid, right? Because getting a big verdict and not collecting it does nobody any good.
Now, I heard a story. Somebody told me a story, Sean, and I don't know if this is true or not, so you can set the record straight if you're willing to talk about it. But I heard that this company was thinking about declaring bankruptcy and that you went into the boardroom and did a presentation to the board members of why and how they should be paying this, along with some type of financial analysis of some sort, of how these fat cats will actually save more money if they pay you $500 million than if they declare bankruptcy. Is that true? Is there any truth to this little rumor, Sean, that I heard?
It's partially correct. I didn't actually go into a boardroom. We had two other cases set for trial that were going to go. We tried this case in July. We had a trial going in October, another one in February. So exact same case, just different little girl, right? So we were going to go and get, $1.5 billion.
Bang them again. Yeah.
Yeah. We were going to get similar verdicts on those. So, they knew they were kind of in a bind. And so we had set up a mediation to resolve all three cases. Now, in doing so, it was a unique situation because we had always known we had a potential conflict because we believed these verdicts were going to be so large that we would have the ability to put this publicly traded company out of business. And so knowing that, we had gotten ethics counsel, we had put our clients all on notice of the potential conflict, and we had a plan of how we would deal after the first verdict. So this was all very well organized, very well predicted. We were in waters that we knew we would be in, right? And a lot of attorneys make that mistake that they have conflicts and they don't realize it. But we had very well acknowledged this early on, and so we went and set up a mediation. And in preparation for that mediation, I did hire a big New York financial firm to give me a financial analysis of what is their real cash position, where can I push them to, where will they get the funds from to pay, how will this all work. And so I did that, and then I hired the top bankruptcy lawyer I could find in Tennessee, which is their headquarters, and also in New Mexico, because there was different bankruptcy potentials with different defendants. And then I also hired the top collection attorney in America to deal with collecting the debt. And so I presented a video that the entire board had to watch prior to the mediation occurring. And so that was a condition. And so the presentation basically walked them through in fact, if you want, I can actually show the video of the presentation that was done when I teach at Michigan, the Trial Lawyer Summit.
Yeah, I'd love to see it.
This is, in my opinion, I think some of the highest level analysis that gets done. And the reason why we do get paid our money on our verdicts is because of, my background is banking. I'm very comfortable in this world. and I'm very happy talking to them in language that they understand. And so what we talked about first was, okay, you have three options. You can settle, and that's why we're doing this mediation. The second option is you'll post a bond. That's a potential, right? But the fact of the matter is, you ain't going to post a bond. And we know you're not going to post a bond because you don't have the cash position to post the bond on the first case. And even if you did, you'd then be pot committed to post bonds on the second and third case, which you can't do. You don't have the ability. So we know that you can't post a bond. So just don't threaten that you're going to appeal and post a bond, because that's not possible. So then let's go to the next option, and that is filing bankruptcy. Now, are you going to file bankruptcy? Are you really going to hit that nuclear button? Are you? Well, we know you're not. Here's why we know you won't do that. You won't do that because, and then we had earnings call. We had like recordings of recent communications that the board had with shareholders, and we had the transcripts. And we're like, you told them that there was no problems here, and you told them that while you're threatening bankruptcy to us. The derivative lawsuit that's going to follow your conduct is going to be massive, and all of you will independently be sued in that derivative suit. And so, we had to understand what derivative suits are and how that works.
Wow.
And I'm like, and that's why you're not going to, and by the way, the other reason why you're not going to file bankruptcy, and then we listed all of their individual names and the shares they owned in the company. You're not going to file bankruptcy because you want your money. You want this money. You won't do it. So really what it is you're going to settle this case. You're going to settle on the terms that we want. That's what's really going to happen. But if you choose any one of these three options, guess what? We're waiting for you at the end of every road.
Oh my gosh. See, that is amazing. And so that case, what happened to the other two cases, if I might ask?
Well, so we end up going to mediation, and we used a phenomenal mediator, a guy named Dirk Murchison out of Texas / New Mexico. And we mediated the case in Dallas, Texas. And so we went down there. It was a 2-day mediation. And it was a fascinating mediation. And at the end of it, they agreed to settle the 3 cases for a global number of $400 million. And
nice.
Our analysis was that again, here we have guardian ad litems appointed by the court. They're not saying no to that number. And more importantly, we couldn't really push them too much further because we knew that we'd push them into bankruptcy. So there was a limit. There was a true limit.
Right. There was a pain threshold there. Right?
Yeah. And so we had to be disciplined ourselves not to push them beyond that threshold. And what ends up happening subsequent to paying us, we couldn't disperse that money until the clawback period for bankruptcy. So we had to let that money sit in a QSF for, the proper time period, which was, we allowed 120 days to go by before anybody got any money. But we were making 5% interest on the money.
Right.
It was fine.
How did you, just practice question, how was it decided how to divvy up that money between 3 respective plaintiffs?
That was all decided well ahead of time, in that the guardian ad litems had agreed that the case that would be tried first would get 50% of the money, and the other 2 would get 25% of the money because their cases weren't actually tried. And so that I thought that that was a decision that was made between all the guardian ad litems, approved by the court. I mean, this was New Mexico is very, very protective of kids, and so the process, every little step we took was being approved by the court. And so we were comfortable with that. We thought it was the right result. And of course, each of the 3 little girls now has more money than they'll ever need to. They're some of the wealthiest people in New Mexico.
That's amazing, dude. Well, thank you for sharing that. We're excited to see you here in Detroit. We're excited to host you. We're gonna treat you right and show you around. Please bring this presentation because we would love to see it, and I'm sure a lot of our listeners who are going to be at the Michigan Trial Lawyers Summit on June 20th and 21st are excited to see and hear about some of your big data, some of this other stuff. You're truly a legend. And thanks for coming on the show, Sean. You're the man.
Thanks, man. Thanks for having me. This was a lot of fun.
All right, everybody. It's been another amazing episode of Cases Gone Wild. A special thanks to Sean Claggett of Claggett & Sykes. He's an amazing trial attorney. Please come if you're an attorney out there who is not on the dark side, of course. Please come to the conference and you can hear and learn more from Sean. I know I will be. on June 20th and 21st here in Detroit. That's mtlsummit.com. If you want to get in touch with Sean or learn more about some of the issues today, you can go to our website, marcolaw.com, markolaw.com, or give us a call, 833-MARCO-LAW. We'll see you in another 2 weeks for another Cases Gone Wild.